Welcome to the Contractor Counsel Podcast.
Welcome to the Contractor Counsel Podcast with Joshua Irvine of Irvine Legal. Joshua is a Utah business and tax attorney who serves as outside counsel to construction and trade companies, helping owners manage contracts, collections, liens, and financial systems. I'm Lisa Mosby, and today we're talking about contracts that actually protect contractors and where construction companies lose money when their contracts aren't structured correctly. Joshua, before we get started, I'd love for you to take a minute to tell us a little bit about your background and how you ended up working almost exclusively with construction and trades companies.
Yeah, thanks for the opportunity. It's kind of been a fun journey. I've always kind of described myself as an entrepreneur. And so I get to connect well with a lot of my clients who, frankly, are on their own entrepreneurial journey as contractors. And so years ago, I started at a really big law firm in a traditional path, but I just didn't feel like a lot of those kind of small to mid-size companies who do a lot in the communities, who support a lot of employees, who really give back, that they really had somebody on their side. Just the sheer cost of legal representation with that traditional model sometimes didn't work. And so, with the support of my wife, I went out and started my own firm and have really enjoyed it. And over the years, have gravitated towards people that I work with a lot in the construction space and really enjoy helping take some of the stress out of running a business for them.
And Joshua, when you review a contractor's agreement for the first time, where do you typically see risk hiding in plain sight?
Well, that's a great question. Unfortunately, a lot of times contractors, and they're probably not the only industry, but since that's who we're talking about primarily, contractors tend to look at a contract almost as a burden or a hassle. And so they really take a very, very high level look at it. They look at just how much money am I getting paid and are the right names of the parties listed. And there probably are 50 other pages that they just didn't look at. And so hey, there are probably three or four main areas that they should be looking at on top of the money and the parties. Number one is the scope of work involved, just to make sure that both sides are in agreement about what they're being hired to do. Number two is to really figure out whether there's a specific timeline that is required to be completed, because there are some things a contractor can't avoid. And if your contract guarantees things, you just need to be aware. And then the third one, especially the last few years, is the cost of the required insurance. Sometimes in those contracts, there's a big long insurance section, which might be so expensive that it makes the job unprofitable. Obviously, there are other things in a contract, but those are probably the three of the most important ones to look for.
If you can't get through those three, the contract isn't going to work the rest of the way. So I totally understand that. When you mentioned scope of work, and you mentioned it first, maybe for a reason, but with the scope of work, is that where a lot of disputes begin from your experience? What makes the scope clear and enforceable versus vague and expensive later?
Yeah. Um, the real, I actually kind of think of a silly example in my own marriage. There was this book that my wife and I read early on called Men Are From Mars, Women Are From Venus. And there were many arguments about how accurate or inaccurate that book was. We laugh about it still. But one of the basic premise ideas that came out of it that I think applies in this situation with scope of work is that both sides of a communication often use different words that mean different things. And so the scope of work is the prime example where a contractor might throw together a scope of work using language and slang terms that are familiar in the construction industry. But a homeowner or a first time builder has no clue what those terms mean. And so I spend a lot of time helping both sides really unravel what what those communication words are. And so that's why I think scope of work probably comes out first. And so the best strategy I have for clients when they're trying to make sure that it's enforceable and that it's clear is to kind of take all of the industry lingo out of it and try to put in here almost like at a seventh grade junior high English level, what is one side expecting to get and what is one side expecting to give? And I find that you either clarify potential confusions or you revise the estimate to align with what the expectations are. But when people go through that process, they avoid the potential dispute later about that very question.
When it can get more expensive, right?
Yeah. Mhm.
So change orders are often where profits start slipping away. What needs to be in writing before additional work begins so contractors maintain leverage?
Yeah, this is true of any kind of a service type of industry. Construction is very similar to lots of others, and so change orders is the fact that you're going to have potential expansion of the project along the way, or you might have a revision that reduces the size of the project due to budget reasons or any number of factors. And unfortunately, a lot of contractors that I work with, and it's probably not unique to the ones I work with, I'm sure it's similar everywhere, they love to text. They love to communicate in really quick shorthand. Some of them email. A lot of things are done on the phone or in person, verbally, and they just don't go through the process of really writing down those kind of amendments to their original agreement. And literally, today I was filing a lawsuit in court about this exact issue, where a contractor believed that there were changes made, but it wasn't exactly black and white in writing. There was a lot of handshakes, there was a lot of text messages, and the client disagrees with what was approved and what was authorized. And so now they're going to have to spend a lot of work because they didn't spend time in the beginning really going through a process and a system of making sure that these change orders are done and signed and saved.
And on top of change orders and the original contract, payment terms look straightforward on paper, but they create serious cash flow pressure. What should contractors be thinking about when structuring payment schedules and triggers?
Yeah, this comes up often because a lot of times my clients only reach out when they are feeling the pinch and or they're in their off season and they can finally turn their attention to financial health. Uh, or frankly, right now, as we're doing this recording, as they're thinking about taxes and they have to realize how to make that work. And so the thing that a lot of them unfortunately don't really spend a lot of time on in the beginning, which is when all of this stuff is created, are the payment terms themselves. There are industry standards that many contractors have just kind of assumed and expected, um, but a lot of times there is an ability to change some of those expected terms so that your business can be sustainable, so that your business can cover its payroll the right way and you're not scrambling every 2 weeks to get one client to pay their bill so that you can pay all of your staff. That's not sustainable in any industry, but a lot of contractors play that game and sometimes they really get burned. And so it's really just being thoughtful of some of the key things to make sure your payment terms have. For example, how do I send an invoice? And where do I send it? And how long are we agreeing that you're going to have to pay? And is interest going to accrue if you don't pay? And all of those things need to be acknowledged. A lot of times clients put generic boilerplate payment terms on like an invoice, for example, but the other side never really signed an agreement that said that they would be subject to those terms. And then there's a dispute later about who is in charge and who can charge for certain interest and whether attorney's fees are involved. Those are all things that should just be in your contract with your client from the beginning. And frankly, if they're unwilling to sign those terms, it might save you more money to walk away from that job than to not have those terms clear from the beginning.
And I think that there's another piece to that contract called the walkaway clause. Walkaway clauses are uncomfortable to discuss, but sometimes necessary. In what situations should a contractor have the contractual ability to pause or terminate work?
Yeah, then this is obviously going to be different, I think, depending on whether you're the general contractor or whether you are a subcontractor. So this probably comes up more in the subcontractor discussion, but I think it makes sense in both scenarios. Bottom line, there are concerns for having walkaway provisions, which means you can leave the job in the middle of the job. Usually, these things are triggered by some kind of a non payment or some other kind of default on the side of the person that hired you, whether it's the property owner directly or whether it's the general contractor who's hiring you as a subcontractor. But you also have to be really careful when you have those clauses because as a licensed professional, you have certain obligations and responsibilities to make sure that you don't leave a project in such disrepair that you I don't know, unintentionally maybe damage your client. And so you have to be really careful on putting it in there. I know lots of parties are reluctant to agree to those kind of terms. But the alternative is, and this happened recently with a client of mine, they were working on a really big job in a kind of an apartment complex that has, we've seen them pop up around the country, but it has 4 or 5 different buildings in this big development. And you can easily have invoices well over 6 figures. And a lot of times those big contractors will say to the smaller contractors, hey, just wait another 30 days or another 60 days for your payment because it's just taking longer than expected. But in the meantime, keep working. And those smaller companies can rarely finance 6 figures of payroll and expense without being paid. And so that puts them in a hard spot. Do I walk away and risk everything? Or do I keep working and risk not getting paid? You just want to make sure you have options in your contract. Not to say you have to automatically walk away at the first issue, but you want to be able to balance that negotiating power, I guess, is how I would look at it.
Preparation is always the most important piece of it long term. Yeah. So, Joshua, where I want to leave this today is when a contractor wants to move from a handshake style agreement to a more disciplined contract system, what does that transition realistically look like inside their business?
Yeah. And this is probably my little fun pet project. I talk about this all the time with my clients, but this is one example of what I call systemizing your business. If you've always been the handshake agreement, and I know plenty of people that they've done that their entire careers and they swear by it, and that's good for them. But best practice is to not do that. So let's assume that these companies are trying to move forward in that best practice model. The first thing they have to do is create a system, something that the owner of the company can train other people to handle, to monitor, to execute. Most of my clients who don't have contracts, it's simply because the owner of the company wears so many hats by default and they don't want to wear one more. So find that really smart superstar employee, train up him or her to really understand, okay, I need to take this piece, the estimate, for example, and I need to make sure that I send this out to the clients to get signed and I need to calendar it so that it's approved and I need to save all these contracts and then similarly I need to update my change orders. That sounds like 4 or 5 steps that you have to do with every job, and it does, and it is. But it's really a commitment for you, the individual business owner, to really build a company, and that starts with creating systems. Contracts is just one of those first systems that you need to make sure that you have. And I'm happy to always walk through and give examples of what it looks like, but once you have it put in place, whether you get a template or whether you hire an attorney to put it together for you, then you just need to make sure your staff understands how to use it, how to take that stress off your plate and make sure the communication's clear with clients. It sounds like a little bit of heavy lifting up front, but on the back end, I think it's going to save tons of time, tons of headache, and keep more money in the business so that you can continue to grow and support your community.
And Joshua, we'll leave it there. Thank you so much for your guidance and your insights today.
Thank you.
That's it for today's episode of the Contractor Counsel Podcast. If you're a construction or trades business owner in Utah and you want more structure around your contracts, collections, or financial systems, you can learn more about Joshua and Irvine Legal at irvine-legal.com. If you found this episode helpful, like, subscribe, and share it with another contractor who would benefit from tightening up their contract process. Thank you for listening, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.